Welcome, folks. As you come in, we have a lot of folks joining this morning, so it's going to take just a couple moments before we get started as we accommodate this rather large crowd. And again, if you're just joining, we have quite a number of folks, so we'll give just another moment or two. Mary, or Laura, my understanding is we have something over 200 people who registered.
Yep.
So we'll give just another minute or two. I don't know if the sound of the lawnmower, they chose today to do the first mowing of our lawn. Laura, is that distracting? Can you hear that noise?
No, I can't hear it, Gary.
Oh, good. Okay. Do you hear that? So let's go ahead and get started as other folks come in. I will tell you, it's been emotionally challenging for me preparing for today. Only twice in my life have I ever attended a presentation where I was totally unprepared, unintentionally. In law school, we had mandatory moot court, and the night before my moot court, my partner took me out for a drink and informed me that she had dropped out of law school a short time before we had the drink. And the next morning I had to make both sides of an argument at moot court without having prepared at all. And the second time is today. I have, notwithstanding the fact that I have tried again and again to jot down some notes in preparation today, I have been had a real difficult time to do it. Now Ernie will tell you that those would have told you that those are not the only two times in my life that I appeared at a presentation unprepared. Ernie and I were at the podium more than 1,000 times together.
Wow.
And as Ernie would tell you, not once was I actually prepared. It didn't matter because Ernie was able to so seamlessly rescue me anytime I got into trouble. So something I'm eternally grateful for. We have almost a who's who in the field in which we work here today, I think, which is quite a notable tribute to Ernie in and of itself. We have, in addition to some very distinguished folks who have asked for an opportunity to make comments about Ernie, pay tribute to Ernie, we have an incredible number of folks who are leaders in the field in every aspect of it, be it as counsel, or be it as government or senior government officials or appointees, or be it as HR, ER, EEO professionals, board MSPB professionals, and so forth. And I'm so thrilled to see the turnout that we have today. We also have present today Ernie's family. I believe they've joined us, and I will have more to say about that a little bit later. Ernie was always proud of his family, and he always managed to get his family into the conversation when we did presentations together. And he was a very loving family member, and cared greatly and boasted of his family at every opportunity. We're going to start today, probably the person who has the longest history, other than, of course, his family, the longest history with Ernie was probably Peter Reuter. We all know Peter for a variety of different reasons, most notably his writing, Peter himself having written some of the most important textbooks for practice in the field, both practice before the Merit Systems Protection Board, practice before the Federal Labor Relations Authority, and a variety of other works that he has done over the years. Peter has knew Ernie very intimately for a very long time. And Peter, you want to get us started here?
Sure. Am I unmuted? Am I working?
We can hear you.
Yeah, okay.
Yes.
All right, thank you all. Annie, Jasmine, Mareed, Luke, and my friends out there in the digital beyond. I am saddened at the necessity, but honored for the opportunity to offer some comments about Ernie's contributions to all of us. Ernie graduated Bates College in 1974, pursued for a while a career in journalism, and then went to the Antioch Law School, where he graduated in 1984 and was admitted to the bar in the District of Columbia in 1985 and later in Massachusetts. Shortly after he graduated, Antioch Law School went out of business, but the degree had value. Witness that he became a law clerk and an associate of Edward Passman, with whom I then had the honor of being the junior partner in law practice. Antioch's student population included a lot of people like Ernie, who had been out in the world doing this and that before deciding to go into law. This brought out a little more maturity and focus in the students than you might ordinarily find from people who went directly from college to law school. And Antioch's focus was on public interest law. Now, people define public interest as they wish, and Ernie did not become a government employee or a judge or a politician, but he did serve the public interest. He was a lawyer representing federal employees, and in the process, Ernie advanced the law of the public workplace. And he was a writer, notably in the area of EEO law, where he wrote the EEO guide for decades. He was a teacher, instructing innumerable students in innumerable classes and forums devoted to the understanding and advancement of the law of the public workplace, and in particular, civil rights law. Those endeavors did not derail Ernie's interest in what was really important in life, and that's his family. His wife, Annie, also from Antioch Law School, 3 children, Jasmine, Luke, Mareed, now adults, none of whom attended Antioch Law School, which by then had been shuttered. Ernie's collateral diversions, children aside, seemed to be baseball, assorted dogs and cats and other creatures, and a 1973 Carmen Ghia, carefully preserved and driven by Ernie with pride. And when did any of us last drive a car with pride, huh? As a lawyer, Ernie's works started with Ed and me in about 1984, and I say about because my memory is hazy on dates. That work continued until Ernie moved to Cape Cod with Annie, leaving the Washington practice beside him, and commencing legal practice in Cape Cod, where his work included a partner, Eleanor Laws, and at various times, several associates and others working in the office. The work was in employment law, both in the federal and the private sectors. Eleanor, in time, became a writer herself and a teacher and a judge, first with EEOC, then with Social Security Administration as an administrative law judge, and now an ALJ with the National Labor Relations Board. Now, along the way, we meet Ernie the writer. In 1984, I took some money from the rather meager bank account that my wife, Patricia, and I shared, and self-published a book on the Merit Systems Protection Board. It sold enough copies to stay in production on an annual basis. Along the way, Ernie the attorney wrote a chapter or two in the MSPB guide, but his interest seemed to be in EEO. And I asked him if he'd like to write a companion book on the law that was being developed through the federal sector EEO program, and he agreed. And he did write that book, annually updating it. It joined another book that I decided to write on the Federal Labor Relations Authority. And together, those three books were marketed as the American Civil Service Law Series through my pet publisher, Dewey Publications, Inc. The books later showed up on information handling services, on Westlaw, Cyberfeds, and although they remain in print, they were also in time distributed on CD-ROM, thumb drives, and now downloadable PDF files. They became over time more expensive, and the end product was lighter, a marvel in American marketing. And without computers, the books would not have been produced, first with the CP/M operating system. Anybody know what that is? Then Windows, Perfect Writer, WordPerfect, Microsoft Word. What progress. Year after year and right on time, Ernie produced the EEO guide starting in 1988. He chronicled the good and the bad about the EEO system. Here's a comment from his preface from the 1989 guide. Ernie said, "I cannot help but be impressed by the number of decisions which end up without even an honorable mention in the guide. Far too many decisions say nothing in the end. In large part, this is because employees file far too many frivolous complaints, and agencies reject far too many valid complaints for frivolous reasons. The result is that precious resources are expended on cases that should never be. Everyone involved in the process is discouraged by the amount of time it takes to process an EEO case. But employees and their representatives and agencies and their representatives could do much by policing themselves to help ensure that the available resources are used so that meritorious cases get the attention they deserve in a timely manner." Sounds about right today, does it not? Year after year, Ernie wrote of the changes, sometimes for the good, in the EEO process. Things those practitioners now new to this field may assume were there with the cooling of the earth, but they weren't. The development of the 16 14-part regulations, the creation of MD 110 in its various iterations, institution and some abuse of the discovery process, the advent of counsel fee awards and compensatory damages, the definition and expansion of the scope of sexual harassment and hostile environment cases, and remedial requirements for agencies to avoid or limit monetary liability, an AJ handbook, the ADA amendments, the Lilly Ledbetter Act, use of sanctions, summary judgment, EEO final decisions from judges, elimination of spin-off complaints and emphasis on complaint consolidation, the change in about 2014 from captioning EEOC decisions from the individual's names to the word complainant, and the backlash that followed about a year or so later, with ultimately a switch at EEOC from using the appellation of complainant to randomly generated first names with an initial for the surname. And I can recall at an FDR conference, Ernie padding around wearing a pin inscribed, "Bring back the names." Ernie wrote or co-wrote other books on labor arbitration, sex harassment, and compiled as a true journalist would a civil service newsletter for a few years. Along the way, Ernie was aided in his work on the EEO guide by Ernest Hadley, Eleanor Laws, Natanya Davis, who took over the book a couple years ago when Ernie and Annie decided to relocate from Cape Cod to Lunenburg, Nova Scotia. That's in Canada. They'd often vacation in Nova Scotia and set up a publishing company of their own called Nevermore Press, producing novels about the life and times of the Canadian Maritimes written by local authors. And then there's Ernie the teacher. Ernie was a speaker at so many federal sector conferences and paid or unpaid teaching engagements. He participated in seminars presented by Dewey Publications, helped to organize and lead the Federal Employment Law Training Group, first in its nonprofit, then in its regular corporate format. He was a featured speaker in audio taped courses on EEO law produced by Dewey. I can recall well several of our joint teaching sessions. One in particular was to the Social Security Administration in Baltimore, perhaps on some aspect of labor law, where Ernie showed up at the seminar and told me he had laryngitis, leaving me on the hook for 7 hours straight teaching with the occasional nod of the head by Ernie. Many memories. That's just one. Ernie brought energy and knowledge to his teaching. He interacted well with his co-instructors and students, stuck to the program, conveyed his point of view without causing undue distress to groups he taught, lawyers or HR staff or management, those for employees, and those for unions. His self-deprecating personal comments interspersed with spontaneous humor were a delight to students and instructors too. And then, there's Ernie, my friend. We knew each other for over 30 years. We dined together, drank together, taught together, wrote together, practiced law together. We visited each other and our families over the years. In recent years, we spoke by phone, probably once every 2 or 3 weeks, about family, politics, cats, and dogs. We discussed all of this with much comic relief. It was a shock, and I am not readily shocked, when Annie called me last year to tell me of Ernie's sudden passing. Patricia and I had looked forward to visiting Ernie and Annie in Canada when the pandemic eased and travel restrictions between the countries had been lifted. It is a loss. Ladies and gentlemen, I enjoyed knowing Ernie, and I will tell you, I will always remember him. Gary, I thank you for the honor of allowing me to provide these remarks.
So Peter, we'll move on to the next tribute in a moment, but I do want you to know, Peter, that I believe that I may be the only person that Ernie Hadley invited to drive that Carmen Ghia that he was so proud of. I will tell you, despite the fact that he offered numerous times, I always turned him down because I just had this vision. I put a scratch on it and my relationship with Ernie would come to an end. So thanks very much for that.
I want to tell you, Cal, that your belief is not well founded. I drove that Carmen Ghia and almost ruined the clutch, even though my regular car is a Miata. So there you are, two people.
Oh, well, yeah, but I was going to drive it with permission. We're going to hear in a moment, just to give you a heads up, Carlton, that we'll hear from you in just a moment. But before we do, we have just two quick comments from some folks who weren't able to be here. And Laura, are you able to put up on the screen? So this is from Chris Griffin. Those practitioners who have been around for a while will recall that Chris Griffin was a member of the commission, someone who Ernie had a very special relationship with. And Chris has written a very touching, she also provided some other comments, very emotional comments I won't share. But for those who may not be able to see it on the screen, I'll also read it because I believe that some folks are only on audio. Ernie was a mentor and a friend. I only wish I met him earlier in my career. When you are appointed as a EEOC commissioner, some assume you are an expert. While I certainly wasn't when it came to federal employment. Despite being a federal employee in my past, I really knew very little about the role EEOC played in the life of a federal employee. I heard about this tremendous expert, the quote, he wrote the book about it, end quote, expert named Ernie Hadley, and I knew I had to meet him. Like me, Ernie was from Massachusetts, and we bonded fast. Ernie became that go-to guy for me on anything to do with federal employment. Ernie was the first person I called when the Biden administration called me to discuss a potential appointment that was a federal employee related. As always, he gave me sound advice from his cabin in Nova Scotia. We didn't talk all the time, but I knew he was always there when I needed him. Ernie, I will miss you. A message from Ernie and from Christine Griffin. And one thing I will say about, just to elaborate a bit on something that Peter said. When Ernie wrote the first version of his book, it was recounting the process and talking about the cases. And Peter read one of the many very telling commentaries that Ernie included over the years. And some people would say that Ernie wrote a book and revised every year that reflected what the commission was doing and how the commission was evolving and the changes in the law and the changes in the commission's interpretation of the law. I would say that Ernie did far more than that. He didn't just memorialize what the commission did over the many years, his commentary, his critique of the commission oftentimes motivated the commission to do things differently, especially with regard to procedural aspects of the commission. In addition to the other things that Peter mentioned, Ernie testified at commission hearings a number of times. I think he was a voice that was very influential with the commission and made quite a bit of a difference. The other comment I wanted to read today is from, can we put the other comment up? Kathy Harris, exceptionally talented attorney who I've known a very long time, have very high regard for. You may recognize the name as being the nominee by President Biden to be the chair of the MSPB. Kathy, of course, knew Ernie quite well, and the comment here, Ernest Hadley's work has been indispensable to all of us who have practiced federal sector employment law over the past decades. He made sense out of what was a labyrinth area of the law and helped all of us achieve justice in the EO field. I'm so grateful for his indispensable contributions to the law. So Kathy had, maybe I should say, Chair to be Harris, had hoped to be with us today and participate in the panel discussion we were going to have about the importance of protections to federal employees, but a personal issue has arisen which caused her at the last minute to not be able to be with us today. And we wish Kathy very well and a speedy confirmation as well. Carlton Haddon, you can take that down now if you would, please. Carlton Haddon is himself an exceptional individual. He has been with the EEOC for many, many years, and he has been the director of the Office of Federal Operations for the now the majority of his tenure with the EEOC. Under his leadership, it would be my opinion, and I think shared widely, that the quality of the decisions that have come out of the Office of Federal Operations has increased dramatically. The EEOC is an entity that is, I think there can be no disagreement, a poorly funded agency that where the staff is asked every year to do more than the year before with less resources than the year before. And while delays of the commission are something that we've all come to expect and regret, it's the important thing is I think that the commission has been a real leader. And I've never discussed this in particular with Carlton, but one thing I will say about Carlton during his tenure's leadership, the EEOC has evolved from an entity which regurgitated the law from the federal government to an entity that has set essentially set the development of law. The commission, of course, certainly decisions circulated to the entire commission, but the commission was ahead of the federal courts in issuing decisions that expanded the coverage of Title VII to include sexual orientation and transgender discrimination, among many, especially had some developments of law in the area of disability discrimination that were paralleled and subsequently by the federal courts. So I was especially touched when I heard that Carlton was going to be available. I know Ernie had a very high regard for Carlton and Carlton. I understand you won't be able to had something had come up and you won't be able to stay with us for the panel discussion afterwards as well. But thanks so much for being here. And here conceptually, here's the microphone.
Thank you so much, Gary. I am honored that I was asked to give a few remarks about our friend Ernie Hadley, and I would start first by really speaking to his family, because even though a year has passed, the loss is tremendous, and it is a testament to the giant that he was, that you gathered this many people together who don't always agree with each other. And that's a healthy thing. That's a good thing in the government, particularly in our area. And I know the focus is on protecting federal employees' rights. And I think that's a great tone, great theme. But I did want to acknowledge Ernie I did not know him personally. And when I had the fortune of becoming the director of the office, it was Ernie's annual message to the community, which really set the tone for what was going on. And I think it was absolutely correct that it really did set the tone. And EEOC, the leaders at EEOC listened and watched those statements. And I recall, I think it was in 1999, I'm not sure which year it was. Ida Castro was the chairwoman at that time, and I was working with her. And we were interviewed by Ernie. And it was, I tried to find that, by the way. I looked for that interview, and unfortunately, because it's like 22 years ago, it feels like yesterday, he was absolutely, in terms of the interview itself and the words he wrote, were very instrumental, because at that time, the commission was going through a transition about how we looked at EEO. And Ernie really set the tone. He was very gracious in his remarks. And more critically, he was critical and called the commission to task when it needs to be called to task. And I just don't think everybody may appreciate the role that all of us have. And I'm, again, honored that I've been asked to provide some comments and remarks about Ernie, but more importantly, the spirit to which he speaks to the community, the federal sector especially. I would say, and I appreciate the fact that I've had the pleasure of sort of sitting at history and watching the evolution of the federal sector. And I've known many of you for many years. And the way I see it is that although it's the commission who has a lot of responsibility, particularly with regard to hearings and appeals, and especially the oversight with how the federal government looks, it is the agencies. I mean, Congress specifically intentionally put the obligation on federal agencies to have a role in this process. And for those who work in the federal sector, we kind of understand it, we go with it. But to those who don't work in the federal sector, it's almost like this curiosity. Well, why is it that a federal agency can have a role in this? Shouldn't we just take it out of the agencies and give it to? Well, then you have to start examining what does it mean to be a public employee, a public servant? And I don't know if Ernie ever was, and I don't think he was, but he certainly epitomized and understood how critical it was that federal employees, we have an obligation to not only ensure there's non-discrimination, but we have an obligation to work affirmatively to make sure that there's a very positive work environment. And the process that we have may not be easily understood, but it's critical for due process. It is a critical process, and we have to safeguard. And I think just speaking for myself, and I acknowledge, Gary, we've had times with the commission where we've not had the resources, and this is not a paid political advertisement, but I am pleased to say that with the current administration, we have been provided tremendous resources to make sure we get our jobs done. We've been able to hire more administrative judges. We're writing attorneys. This administration has been absolutely dedicated to making sure that civil rights and equal employment opportunity, diversity, and inclusion is not simply things that they say. They are core values. And to be honest, I regret that Ernie can't be part of the dialogue right now, because I think a voice like his is a voice that is really needed. So that's all. I mean, I'm not a talker by nature. For those who know that, I don't have a lot to say other than thank you. And in particular, I would thank Gary. Gary and I have worked together for such a long time. And at one point, I think we were talking about not being prepared. And it was Gary and I who were at, this is many, many, many years ago, when Gary was at the commission. We were at a speaking engagement. I had a bad evening. I don't know what was going on, but I wasn't really prepared to make a presentation. And I had Gary as my co-presenter. He, without a moment's notice, just made sure that the commission looked well. And I've always taken that as a real statement as to who Gary Gilbert is and how fortunate we are to have him as well as the others as one of the leaders of this community. Again, thank you so much. And I'm going to stay as long as I can, but I'm really delighted and honored to be here. And again, my condolences to the family. We know how difficult it is to have someone like Ernie out of your lives. Take care. Thanks.
The next speaker, Carl Nodley, interesting enough, the three of us have something in common. And that is we were all three at a conference in Berlin some years ago. I can't remember what year it was, but I have, if there's ever an opportunity to roast either one of you, I have some great stories from that conference. But do you recall what year that was?
No, it was in the 1800s, I think, or 1700s.
I know all three of us were a lot younger in those days. But the next speaker, Beth Slavitt, who I've had the pleasure of sharing some very delightful professional as well as some very fun personal moments at conferences and such with over the years. Beth Slavitt has a very distinguished career, and I did not look up her bio, so I'm going to do this. And if I get this wrong, Beth, feel free to mock or criticize me. But she spent some time on the Hill working for, if I remember correctly, Senator Ted Kennedy's committee on the staff there, and she was appointed among the highlights of her career. She was appointed to be the chair of the Merit Systems Protection Board. And I'm going to think that was in 2000, and it was by President Clinton, if I have that right. During her tenure with the commission, actually with the board, both as chair and as a member of the commission, she distinguished herself, among other things, by some exceptionally well-written decisions, both as writing on behalf of the majority and commenting when on the occasions when she was outvoted. One of the things I recall most about Beth Slavitt is a conversation I had with Ernie Hadley, and that conversation had to do with the fact that as chair, I think it was as chair, that Beth Slavitt was the first person on the board that we thought had consistently understood issues of discrimination and compensatory damages. And that was really a sort of an exciting development within the board. So we're really pleased to have Beth here to make a few comments. And Beth, feel free to criticize my summary of your, and I should mention right now, Beth is running a really wonderful program, mediation program over at the Department of Labor, a very important program. And Beth, go ahead.
Well, first of all, thank you. I'm honored to be here. It's been a long time since I've spoken or indeed thought of Ernie. And I want to give my sincere condolences to Annie, his spouse, because I know how difficult it is to lose your spouse. What I enjoyed about Ernie was he was just like a great guy. You know, he was fun. He could be self-deprecating. He had a great sense of humor. He was not officious in any way. But what I really admired about him was that he practiced law out of Truro and Wellfleet, Massachusetts, because Truro is my nirvana. Right now, I'm speaking from my college roommate's house, and they have a home in Truro that I've gone through for years and years and years. And when I would go by in Wellfleet and see Ernie's office, and I think the one time I knocked on his door, he wasn't there, right around the corner from Max Seafood, I was envious, because here was a guy who said, okay, I'm getting out of Washington, D.C., and I'm going to one of the most beautiful places in the world, and I'm going to practice law there, far before anybody did, we did this telecommuting that we're doing now. And then when I saw that he moved to Nova Scotia, it was sort of the same thing. What a wonderful thing to do for yourself and for your family. And that just said a lot to me about Ernie. So I am very sorry about his loss. As we all get, older, we unfortunately lose more of our colleagues. But so thank you for allowing me to participate. And again, my sincere condolences to his family. May his memory be a blessing for all of us.
And I understand Beth won't be able to join us this afternoon or later today. I just do want to note that the office where you work, which if I'm correct, primarily deals with mediation in cases brought by whistleblowers under OSHA, and what important work that is. And
it's like 22 whistleblower retaliation statutes. And the most that we deal with federal employee issues probably has to do with environmental cases, EPA employees, etc., employees who work for a particular department, but whistleblow with regard to an environmental issue.
So thanks very much. And the next person we have that's going to pay tribute to Ernie is somebody very special to me, a very dear friend, colleague that I've known, if I recall correctly, since he joined the EEOC, and I believe it was 1987, Don, if I have that correctly. Don joined the commission as he had this fancy title that nobody knew what it meant. It was called Director of Special Programs, and I was a judge with the EEOC at the time, and all of the judges thought this was very amusing because nobody could figure out what special programs was or what he did. And I will tell you, it took Don at least 3 days before he won over all of the judges. And he became someone who is not only a friend to all the judges, but someone who commanded tremendous respect. I don't recall whether you started the digest or whether you just took the existing digest and turned it into again, we've seen, as much as I was saying about Carlton, we've seen the evolution at the EEOC of some really high quality work, and some of which we're not going to address today because it's not all federal sector. But the digest, if anybody has not taken advantage of the digest over the years, I won't comment on whether it's improved or digressed since Don left the commission, but it was a wonderful tool. Don was a very influential member of the commission. It was a very sad day when Don decided to jump ship and go over to the other side. So Don, you spent some time doing some very good things at the Department of the Navy, and I've forgotten where you are now. Where are you now?
Can you hear me? Am I hooked up and unmuted?
Yes.
You are.
Oh,
unmuted.
excellent. Great. Sorry, just had to ask. I've gone on a little bit of time before people just finally said, we can't hear you. So Gary, it's been, I'm now at the National Credit Union Administration, dealing with things like fintech, which I'm still really trying to understand, cryptocurrency and things of that nature. But, life is an adventure. So thanks for the introduction. And honestly, I did not start the digest, but I had a great time. And I think that's one of the things that Ernie and I had in common, was that we just wanted to let people know, what's going on, what's the latest. Interestingly, because I had never thought about that until you just mentioned the digest, that was something that I started back in, doing that in 88, maybe 89, and had the privilege of doing that for some time, and part of that time with Carlton. So it's great to see him and great to see everybody assembled here. Can I get going, or did you have more?
You can certainly get going. I actually, I will throw in one last thing, which is Don shared the podium with any number of other folks with Ernie. And Don wasn't on the podium quite as often with Ernie as I was, but quite a bit. And with me and Ernie, it was a lot of fun. And oftentimes he's now on the podium with Darren Sumner, who we're going to hear from shortly. Go to it, Don.
Thanks, Gary. Yeah, first of all, Gary, thank you for providing us this opportunity. I've tried a couple of times in presentations after I heard the news and simply couldn't get the words out. So I really appreciate the opportunity to do what we don't do enough of, which is to honor and acknowledge a great man, a wonderful human being. And I'm so glad his family is here with us as well. The first thing that I think of, honestly, when I think of Ernie Hadley is not that he was the foremost authority in EEO law, but he was, and not that he was the hands down favorite presenter at any federal personnel conference anywhere, because he was. Every year, the FDR conference would do a kind of a informal tally. Who was your favorite presenter? And it was always Ernie that people wanted to just hang out with after the presentation. So that was just the way he was. But those aren't the first things that come to mind. He was the EEO case law expert, there's no question. And he was by far the most popular presenter, and he was so much fun to present with. The first thing I think of is that big smile of his. Just as you walk into the room and you see that smile and you get that feeling like he's a kid that just saw his best friend. And it just made you feel so good. And after a while, I'd get the smile and the hug. And that was just wonderful. He contributed so much in so many different ways. But let me take you back to the 90s. When I first met Ernie, and this is just a quick anecdote, I was in a very public forum. I was speaking at the very first EEOC XL conference. It was up in Hyannis, Massachusetts, and I was holding forth on compensatory damages, and I felt as though I knew enough about it to give a presentation on it. I was pretty green. This was a big audience for me. I probably hadn't ever presented to a group as large as that. It was a major forum. And I was talking about compensatory damages, going through the case law. And as I was describing what I'm sure at the time were the recent EEOC decisions on compensatory damages, a topic near and dear to Ernie, a somewhat rumpled gentleman raised his hand and stood up and asked very loudly, what do you have to do short of bringing in a body bag to get a decent award of compensatory damages? Well, you can imagine, I mean, what does a kind of a junior green presenting attorney say to such a thing? So after I'm sure I stammered a little bit, I did my best to describe, well, you know, we have to show evidence of harm and causation and link it to the discrimination and all that, and all kind of going over the basics. Honestly, I wasn't quite sure what else to say, but I did happen to say, and the press was in the room, that it appeared to me as though the commission had been rather conservative in its compensatory damages awards. Well, that comment made its way into the press. And I learned after the fact, because I didn't know at the time, that the questioner, the poser of the question, was in fact the inimitable, the famous Ernest Hadley. And then I learned something else about the power of the spoken word in a public forum when I was invited into my supervisor's office for a little chat about the wording that I chose to describe commission decisions. At the time, it was a Democratic administration. So I was off the speaking circuit for a while. Well, as memories faded, I was allowed back on the speaking circuit. And I was lucky enough to have the opportunity, as Gary said, to present with Ernie any number of times. And every time I'd see him and he'd give me that big smile and the hug. And I learned in getting to know him and speaking with him afterwards or having dinner with him about his passions. And yes, he was very passionate about the rights of federal workers and doing the right thing. He just stood for doing the right thing. That was Ernie. He was also, I learned, fiercely devoted to his family. And yes, it's a theme that you've heard, that it would always come up and would talk about his family. And I can relate to that as well. Well, as the years passed, I could pretty much count on running into Ernie at whatever conference I was going to. And every time, he always made me feel special. Every time I'd see him and we'd chat. So when I got the news last year, yes, I too was shocked. And honestly, I couldn't help but think of that song by James Taylor, I'm sorry, Fire and Rain, because I always thought I'd see him again. He was just that way. He just was invincible in my mind. So, of course, Ernie lives on through his family, through us, all the people that he's taught over so many years. He lives on his publications, which are still there, and which I still refer to on a regular basis. He lives on in the person that, although he may be annoying, in a presentation I'm giving, I don't know where, stands up and raises their hand and says something about, this doesn't make sense. Help me understand help me understand the law here. Help me understand what the commission or what the federal courts are doing. He lives on in that spirit. Wherever you see an impassioned plea for justice, I see Ernie, I really do. I don't care where, I don't care what the cause. I think that's who he was. He took a stand and he made a difference. And along the way, he made us smile and made us feel special. And I only hope that people will say the same about me. And that's it.
Ernie told me any number of times over the years, Don, how greatly he appreciated your candor when you responded and nearly, I think perhaps you may be greatly understating the repercussions from your candor at the commission at the time. I remember those days, and it's like we were writing postcards to Don in Siberia. But like Ernie, one thing that I think a lot of people have respect for you, as they did with Ernie, was the fact that you call it like you see it, and that's something Ernie always did. He didn't mince words, and he didn't play the let's be overly polite. If there was an injustice, he spoke about it, and that was it. So thanks, Don. So the next speaker is someone who also knew Ernie very well. She's someone who's had a stellar career, who's written an unusual book for Dewey Publications, as well as having spent some time as a counsel practicing law with Ernie. She spent a little bit of time with us as of counsel or to the law firm, if I remember correctly, and spent time as an EEOC administrative judge, and then went on to be an administrative law judge, and with the National Labor Relations Board most currently. And I actually, Eleanor Laws, I don't remember where you are, Eleanor. Are you in Portland? Do I remember that correctly? Or?
I am.
You're in Portland, okay. And what could be a better pinnacle of a career than to have a cushy job as an administrative law judge. Oh, and there we go, National Labor Relations Board.
Yeah, no, I know. I didn't change my background because I have to go right back to work after this. So,
Yeah. So, and I should note that Ken Chu, our friend and colleague, who's also with the National Labor Relations Board after having been the chief administrative judge for the EOC in New York, was supposed to be with us today, but he had a last minute emergency and sent his regrets. Eleanor, what do you have to say about Ernie?
well, first I want to thank you, Gary, for pulling this together. I think we all really appreciate it. I think we all felt pretty raw about a year ago, and I think the timing is wonderful. We've all had a chance to process things, and when I say we all, I realize that that's probably not true for Annie, Luke, Mairead, and Jasmine, and I'm so sorry for your loss. I really can't imagine. And so many people have spoken about Ernie's stellar career, and it was, but I want to bring you all back to a time early on in his career, and I see Jolene Olson is here. I first met Ernie when I took a job with his law firm, and I think Jolene would agree. It was eclectic and it was fun, and I think those two words describe Ernie perfectly, and it described our work environment. We were in this duplex in the middle of nowhere in Wareham, Massachusetts. Our landlord was this just really, really worldly guy, Jack Nolan. He was an engineer from MIT, but he lived in the sticks in Wareham, and he was a sometime auctioneer. He had an attic full of junk that he auctioned off. And my work life consisted of working and then sitting every day at lunch with Jolene, Ernie, and our admin assistant, Leslie Burrell. And we just talked about everything. And Jack would pop in with his wisdom, and the next door neighbor, Bruce, would pop in. And it truly was like no other person's law firm experience who I've ever talked to. And it was just wonderful. And it was like a family. And speaking of his family, I'm gonna bring back a little memory, and I'll be quick about it. But the first time my husband Brian and I went over to Ernie's for dinner, some of you probably know his wife is a fabulous cook, and she's also a vegetarian. My husband is a carnivore who can't cook. A slab of meat and a potato would be perfect for him. So Annie made this gourmet dinner. I still remember, I think it was Musaka, and Brian, trying to be polite, Brian's my husband, was cutting it into tiny pieces and just kind of swallowing it down. And after dinner, after the next day, we were talking, and Annie said, much to, I think, Ernie and Annie's humor and delight and my chagrin, I'll just make Brian what I make for the kids from now on. And, it was just one of the many funny anecdotal stories I have about time spent with Ernie. But, in all seriousness, I owe my career to him. I owe, in many ways, the development of the passion for what I do to him. He led by example. And as Don said, his work lives, he lives on through his work, and much to my dismay, I'm currently, as Peter Broyden knows, updating the workers' comp guide, which he helped me start ages ago. So he continues to live through that book and all of his other publications. But I think, most of all, he lives on in our memories. And they're just nothing but positive and fun. And he had that just unbelievably dull balance of being so positive and so fun while doing such serious, important, grave work. And he thread that needle perfectly. And I don't know really many other people who could continue to live life and just spread such joy while doing really, really deeply important work, disturbing work, oftentimes, helping those who were down while lifting everyone up around them. And that's how how I will always remember Ernie, and I'm sure how all of you will always remember Ernie. And I'm eternally grateful to him for giving me such a unique platform from which to launch.
Thanks. Thanks very much, Eleanor. So good to see you. Are you still keeping your textbook up current?
I am. I'm, as we speak, spending my copious free time updating the workers' comp guide, which, by the way, Ernie helped me co-author the first one and then said, I can't stand this topic. And left me to update it every year, which was fine. He, helped me do the hard work at the beginning. But yeah, well, thanks again, Gary. This was really a fantastic idea and long overdue. And it's great to see so many faces connected with Ernie.
That's great. Your textbook on workers' comp is one of the most, I think, underrated publications, because it's such a complex. That workers' comp is sort of complex to begin with, but the federal sector aspect of it is. I am impressed that you did it and you continue to do it.
Well, thank you. I'm grumping about it, but in all honesty, I'm glad very glad Peter gave me the opportunity to do it, and updating it just forces me to stay current with it, which I probably wouldn't otherwise. So.
Yeah. I should also, since we're talking about the textbook, I've been very had a very difficult time focusing. Well, for the past year, but especially in the days leading up to today, and with apologies, I should have said at the very beginning. I appreciate everybody being here today, and I want to especially note that the two co-sponsors, in addition to the training group that we do, the two co-sponsors, which of course is Dewey Publications. How could they have a program about Ernie that didn't include Dewey Publications? And also LRP Publications, which does among other things, does some great things, cyberfeds and FDR. And I just appreciate their help in putting this together. Everyone volunteered their time and resources, and obviously we were able to do this without, as it should be, a tribute to Ernie that didn't require anybody to kick in any funds or money or anything. So the next person who is going to speak, and that would be Dwight Lewis. So Dwight is another awesome individual that Ernie was especially fond of. And Laura, let's hear from Dwight, and then we'll take a 5-minute break after Dwight, if that's okay with you. Dwight, I've known Dwight a very, very long time. Dwight was a very influential individual during his tenure at the EOC. Most notable during his many years as the chief administrative judge for the Dallas District Office at the EOC, where he moved the commission forward in a variety of ways, serving on any number of committees that dealt with changes to the regulations and procedures, the MD 110, the commission's regulations. Another area where I say that Ernie had his footprint, because those of us, and I served on many of those committees with Dwight, those of us who did that, we sort of brought Ernie's thoughts and philosophies into the room with us as we had those things. And Dwight is of counsel with our law firm now, but he's another individual who shared a podium with Ernie any number of times and was a very dear friend of Ernie's. Dwight?
Thank you, Gary. Thank you, Gary, and thank you for the opportunity. First, my condolences to the family. I know that was a great loss for you. And I know since I've had loss in my own family that way, I know how devastating that can be. I want to tell you that many of you may not know this, and probably for good reason, But it turned out, I know that Don mentioned this, but when Ken Chu, who I thought was going to be on this panel, started work on the Excel conference for the East Coast back in 1998, I wanted to compete with him for a conference for the West Coast. And I was tasked to plan this Excel West conference along with 6 constantly squabbling district directors. And I was set to do the planning and to set up the witness list. And I went into this meeting with them and I told them that if you're going to have a conference of this type, that you're going to have some heavy hitter speakers in order to compete successfully against the Excel conference that Don mentioned earlier. And I told them that there were 3 critical people that I needed. And one was 2 were on this panel because one was Don Names. And I said, you know, Don's sort of a shoe-in because he's a friend of mine. I want to be looking at him, not going to be any problem. But the other 2 I really don't know, and we're going to need them too. And one was Peter Brody, and the other was Ernie Hadley. And I didn't know whether, you know, it was a long shot that I was going to be able to get those 2 at all because I didn't know them. And so I contacted them, and they graciously accepted the invitation to appear at this conference. And my good friend Don Names unceremoniously sort of blew us off. So, but both Ernie and Peter were going to appear at the conference, and I have to tell you that they did know me. And I remember watching Peter walk up to the hotel at the conference, and so I met up at the conference, but I was watching him from a distance, and I didn't know him, and I thought this guy's going to be the smug, high-minded brainiac professor sort of guy. And I based that on, you know, his sort of impressive treatise on the EEO law, and I just thought that was the sort of guy he was going to be. And I was shocked and amazed to find that he was the most congenial, hilarious, down-to-earth guy that I had ever met. And he was both brilliant and humble, a quality you rarely find in people, but you always see, but you just don't find in people these days. But I remember we sat up, and I don't know if Peter remembers this, but you know, it was the night before the conference. We had a lot to do. But I spent the entire night in the hotel bar telling jokes and just howling at Ernie Hadley's stories all night long. And it was the beginning of a friendship that would last for decades. And I appeared with him in conferences for years after that. It was always a great time. And, you know, he's just a great friend, just sort of a unique person that you'll never ever find. You know, I always think about, you know, I've been at a few funerals lately, especially with COVID. And they always make this statement that this is a person who lived a good life and that they can never be replaced. And sometimes that's true, and sometimes it's not. But in Ernie's case, it's not only true. There won't be anyone who will ever come close to filling Ernie Hadley's shoes. He was just a person like no other, and just a you know, professionally one of the best you'll ever find. His ability to, you know, dissect EEO law was unparalleled, and also as a friend and a person that you could approach and talk to about just about anything. To find those 2 things in one person is just not found these days, and so we've suffered a great loss in the professional community, and I know that many of us have suffered loss as a great friend. And thank you for allowing me to say that today.
Thanks very much, Dwight. Let's take I think some of the folks want to use the restrooms. Let's take a 5-minute break and pick up again at 1:10. We will finish a few more comments about Ernie, and then have a discussion about a topic that was very near and dear to Ernie, which is making sure there were appropriate protections for federal employees. Okay, well, welcome back, everybody. So let's see, I think if I'm not mistaken, that brings us to Ren Fowler. Ren is an institution. Ren's been around a very long time, spent some years with the GSA, and if I'm not mistaken, Ren both in Washington and San Francisco. I've known Ren for just a little short of an eternity, Ren, and by the way, Ernie and Ren and I and Peter have been involved in so many different iterations of federal employment training. It's hard to remember them all. But the old Dewey seminars, which were of course put on by Dewey Publications, the Federal Training Foundation, Chuck's group, which I've forgotten the name of it, the Federal Training Group, maybe, the Federal Employment Law Training Group, FELTGE, which Ren and Peter and Ernie and I were founding members of when it was a nonprofit. We've since left it and gone on to other things for reasons we won't discuss today, including Ernie. Ren's been a speaker at any number of programs over the years, again, also with Ernie. Ren's written any number of publications, including his Charges and Penalties, which is somewhat of a Bible for understanding charges and penalties before the MSPB. Ren, always pleasure having you on the panel here. Do you want to go ahead and make some comments?
Yes, thank you, Gary. I'm sitting here thinking there's so many admirable and anecdotal things we can say about Ernie. But I think everything distills to this. He made so many lives so much better. And that's to say he used his life to make a difference. And I would hope I could say that about myself, but he did. He used his life to make a difference. I really think, again, listening, Peter and Beth really nailed a lot of things about Ernie. And one, Peter mentioned Ernie went to Bates. And I was at a Christmas party and a young lady comes up and says, Mr. Hadley, I understood you went to school in Maine. And Ernie says, yes, Maine has these 3 little ivies. And the saying goes is, if you're smart, you go to Bowdoin. If you're rich, you go to Colby. If you're neither, you go to Bates. And Ernie said, I'm a neither. I went to Bates. And another sort of interesting thing, I get this call from Ernie once, and the backdrop is this. The backdrop is this. You know, when you go out on the Cape, there's just one road going up, and in the summer, it just doesn't move, and people are continually looking for off ramps, and there's nowhere to go. There's no alternative. There's water on the left, water on the right. So you're stuck, but people continue to look for these off ramps. Ernie calls me and he says, you won't believe this. I'm calling you because I know you're a big fan. I'm futzing around with leaves in the yard, and this car pulls up in the driveway and starts to turn around. And he said, so I go over and look, and it's Woody Allen. So there you go. Another thing, I did a training once with Ernie and Peter, and we're coming back from lunch, and Peter says to me, you're going to represent me in a depot demonstration. And I said, okay, well, how is this? And he says, Ernie is going to depose me, and the theme is I'm a baker. So, you know, we set up the thing, you know, I walk over, I look for a chair, and out comes Peter in a baker's uniform and one of these big high white hats and so forth. and I'm thinking, oh my God. But let me ask you guys out there, how many have had to oppose Ernie with Peter as a client? Talk about a rock and a hard place. And I'm like the deer, I'm like the deer in the headlights. And Ernie noticed and took care of me, and we got it done. Let me just stop by saying this or end by coming back with how I started. Ernie made a difference, and we'll always remember him. And as Beth said, he had that smile, and we'll always remember him with that smile. We love you, Ernie. We remember. Thank you, Gary, for letting me talk.
Thanks, Ren. You reminded me, among the many things Ernie has done in life, I sort of forgot about this one. Ernie actually represented a whistleblower, and Ernie was always willing to do the right thing. He sometimes took on agency cases from time to time as well. But Ernie represented a whistleblower. Late 1990s, if I remember correctly, George Galatas, who I started my legal career working for the Nuclear Regulatory Commission back at the end of the 1970s, early 1980s. And some years later, Ernie represented a whistleblower, again, Galatas, at the Millstone nuclear power plant. And it was much as a result of Ernie's representing the Galatas that the plant identified very serious safety issues, and the NRC reached an agreement with the plant to modify. That alone made a huge difference in terms of public health and safety. Yet another tribute to Ernie. I bet Annie remembers those days well. We have as our next speaker, we have, I think let's see, we didn't find Tanya, did we? So we have Ed Passman. Ed, when I came to the commission in 1986, to the EOC, I came briefly as an administrative judge and then chief administrative judge at the commission. We didn't have any real technology then, so I had a spiral notebook in which I kept track of all the cases. And I still have that spiral notebook that I used the very first one. And the first 36 cases they gave me, I had among the lawyers representing parties in those proceedings, I had Joe Kaplan, a good friend of Ernie's, and a tremendous lawyer, incredible lawyer and incredible speaker, who of course passed away a couple of years ago now at the beginning of the COVID pandemic, and who we continue to miss greatly. But I had Joe Kaplan, I had Ed Passman, and Peter Broider, which, if I recall correctly at the time, and I had Ernie Hadley, all of whom at the time I think were from the law firm of Passman and Broider, if I remember correctly. So Ed, you have a relationship with Ernie that goes back about as far as the relationship with Peter, if I'm not mistaken. But let me turn it over to you. I should also say Ed is himself an icon in the field. There's nobody more talented than Ed, so thanks, Ed. And,
well, thank you, Gary.
You want to put? You don't have to, but would you like to put on your video?
Sure.
There we go.
Okay. Well, let me come back. Hold on a second. We go. Well, hi. I was shocked like everybody else to learn about Ernie's untimely passing. While in recent years, I didn't have too much contact with Ernie, my late partner, Joe Kaplan, did, because he represented the firm in many training conferences where Ernie also participated. But back in the 1980s, a long time ago, with Peter Broida, Ernie was a very fine advocate, and we all worked together and enjoyed the practice. But in addition to practicing law, as somebody had mentioned earlier, Ernie was a baseball fan. And Ernie and I went to many games at Orioles Memorial Stadium. And that was long before Camden Yards. And the stadium was in downtown Baltimore, but we would make the trek, and Ernie was a rabid fan. In addition to going to baseball games, one time we went to the old Washington Star tennis tournament in DC. And we enjoyed it so much that the time the matches ended, it was after midnight. And we had no way of getting back to the Silver Spring Metro where our cars were parked. And we were standing out there on 16th Street long before there were smartphones, and figuring out what to do, and thought we'd have to hike up to Silver Spring. But fortunately, somebody drove by that recognized me and gave us a lift up to the Metro. But during that time, Ernie was in good humor, and he was really made it enjoyable. So in short, Ernie was a really great guy, a fine lawyer, made tremendous contributions to federal employment law, and he is sorely missed. Thank you.
Thanks. Thanks very much, Ed. And Darren Sumner, who has presented with Ernie and Don Names and at numerous conferences now, co-authored some books with Ernie. I remember the days when Darren first joined Ernie and myself at the podium, and Ernie and I, one thing that those of you who have attended seminars that Ernie and I presented together at probably know that there are a certain number of stories that we have to tell every time we are at the podium. And Darren, I would say after the third or fourth time of having to sit through Ernie and I telling the same stories over, we began to anticipate the rolling of her eyes when we got to those stories, which didn't deter us in any way whatsoever. But Darren, I know you also miss Ernie greatly, so please go ahead.
Thanks, Gary. Yes, I represent those of us who've known Ernie in more recent years compared to our other esteemed panelists, which is to say that I first met Ernie in 2005. So I know in this crowd, that's considered barely a blip of time. But at this point in my life, I will take any opportunity to feel like part of the young crowd. And I know some of my friends and colleagues who are here, Administrative Judge Stephanie Herrera, Kevin Owen, Shannon Leary, who knew Ernie just as long as I did. And I know credit him for helping us become the attorneys that we are today. As Gary mentioned, I had the pleasure of knowing Ernie through writing some books together, trying cases together, and presenting at trainings together. I was honored to help him update 2 books on the EEO process over a decade ago, and learned that unlike working with Gary, when you work with Ernie, you do actually meet Peter's contractual deadlines to timely submit books. And I got to learn so much about litigation when we co-counseled a whistleblower retaliation case before the Merit Systems Protection Board many, many years ago. I know I credit Ernie for teaching me, along with many of my colleagues, about how to use very direct and concise language in our written advocacy on behalf of clients, and how to use short sentences without unnecessary filler words. When I sat down to think about how Ernie had impacted my legal career and who I am as an attorney today, a few things stuck out in my mind. One was how Ernie always took the time to provide positive feedback about how I was doing in our work together. And another thing that I fondly recall is how Ernie always treated my colleagues and me as equals, and he really valued our opinions, even though we did not have nearly as many years of experience litigating or giving presentations. But one anecdote really stuck out in my mind that I think really characterizes who Ernie was both as an attorney and as a person. And that's a conversation we had many, many years ago where we were representing a client with a disability. And I was laying out the legal analysis of the case, and I offhandedly referred to our client as a quid, or qualified individual with a disability. And Ernie very gently and very appropriately reminded me that our clients are not quids, they're not acronyms, they're real people. And I think that Ernie really emphasized that both in how he handled cases and in presentations, the importance of treating employees and clients as individuals. He was very quick with laughter. He always made it a point to ask about my family, and he loved to talk about his. And it was a real joy to see him in recent years go back to school for writing and his work as a publisher. And it was clear, although he loved to play in our federal sector world, his real passion was the creative writing that he was doing and working with other writers. So very grateful to have had the opportunity to work with him, even if I didn't have as many years as some of our other panelists here. Thanks, Gary.
One of the things Ernie was served as of counsel to the law firm, although he helped any lawyer who needed help in the field, plaintiff's lawyer or agency defense lawyer. He was always willing to provide his thoughts. But one of the things I always found amusing was Ernie was the best legal writer I ever met. He could write persuasively and concisely in a way that few are able to master. And one of the experience I saw time and again with less seasoned, as I like to call young lawyers, less seasoned lawyers, would be when they would send Ernie a draft of a document and they would say, can you help me? I have a 20-page limit and I've got 24 pages and I just can't find anything to cut. And 2 hours later, Ernie would return the document saying, well, now you have 5 pages you can add because I've got it down to 15 pages. And he would never remove anything that was important. He would say things so eloquently and concisely. It was really a marvel to work with him. I was and I remain envious at his ability to do that. Ernie was such a good friend. Everything we did together was fun. Everything. It was never, my dad used to say, if you like what you do, it's not work. And with Ernie, I never did a day's work. I never did a minute's work because there was never a time when it wasn't fun. Now, admittedly, Ernie did all the work because he did all the preparations. He did all the slides. He did the outlines. He did all the preparation. And I showed up at the podium and, I kind of knew the law. So I would wing it. And as I said, time and time again, as the slide came onto the screen, that I was seeing it for the first time. So Ernie mocked me relentlessly. I am very, very colorblind, and one of the fondest memories I have of Ernie, we were presenting at a very large conference. There must have been at least 1,000 people in the audience. And as always, we showed up, Ernie and I both showed up for a 10 o'clock presentation into the big conference room at 2 minutes of 10. And so we immediately went on to the podium. And as we're climbing the steps, Ernie turns around to me and he looks at me. He knows I'm colorblind. He looks at me, he looks at my tie and looks at me. And, there's 5 steps up the podium. And he says to me, are you going to wear that tie today? And I said, well, yeah, Tony, yeah, Ernie, it's showtime. I don't really have a choice. And he says, I wouldn't. And he goes up. And now I have to give this presentation. And the entire time I'm convinced the audience is staring at my tie because it doesn't go with what I'm wearing. But it gets worse because the very next day we're doing a repeat performance on another topic. And same thing. We walk into the conference room, we start walking up the steps. Ernie turns around, looks at my tie again, looks at me and says, and that's the tie you're going to wear today? I said, yes, why? He says, I like the one yesterday better. And that was the kind of wit that Ernie always had. We did a program for the Air Force one time in this new multi-million dollar training facility they had in Massachusetts, South something Massachusetts. Beautiful facility. And Ernie was all excited. And so he had this enormous whiteboard with a television screen behind the whiteboard. And it was just so state of the art. And Ernie got all excited, and he never used to put things on a whiteboard, but he starts marking on the whiteboard with these markers and doing things. And as he's doing that, there came a point in time when I went over and I looked at the markers, and they say permanent marker on them. And at a break, I go over to Ernie. I said, Ernie, I think these are permanent markers. And it turned out that Ernie had just desecrated this incredibly expensive whiteboard that they got, that they had purchased with the television screen hidden behind it. And Ernie, of course, had the only reaction he ever had to things like this, which was to laugh hysterically and suggest we get out of there as quickly as possible after the program ended. Ernie and I were in Rhode Island one time, and Ernie drank decaffeinated coffee most of the time. I drank regular coffee, and we had breakfast together. We ordered coffee, and the waitress comes over and she pours me some coffee from one pot, and then she pours Ernie coffee from the other pot, presumably decaf, and goes away. And later we wave her over and say, "Can we get some more coffee?" And she returns with one single pot, and she pours coffee for me and Ernie from the same pot. So I called her back and I said, "Did you realize that I ordered regular coffee and Ernie ordered decaf?" And she said, "Yes," and walked away. And Ernie and I decided we didn't need any further explanation. That was good enough for us. So, anybody who knows me has heard me say this comment, and that is, there is no single aspect of the work I do that holds a candle to the fun and the enjoyment that I had over the years with Ernie. Ernie was a beloved colleague. He was one of the smartest people I ever met, one of the best writers I ever met. And he was such a good friend. And I had always, we expect things to be the way we intend them to be. And one of the things that I was looking forward to was the continuation through the end of her career. That was going to be getting back up on that podium with Ernie. And God, I miss you, Ernie. God, I miss you. Thank you, everybody, for having come today. We're going to just transition, and we're going to have a bit of a discussion. As you heard so many people say, what was one of the things that was really important to Ernie was the fact that we provide protections to federal employees. It is something that I always say makes us different than most of the rest of the world. The fact that we have a civil service that is, for the most part, not infected with graft or with, relatively so. Of course, all entities, governments do some. The fact that it is, we have protections for whistleblowers, the fact that we have so many means to ensure that the civil service is not improperly influenced by political motivations or affiliations. That's what makes us different than the rest of the world. We have a civil service that looks like who we are, whether we're talking about the color of our skin or our ethnicity, or whether we're talking about the fact that we are empowered to speak out when we see injustices and we see when we engage in whistleblowing conduct. And so we're going to have a bit of a chat about that. And those folks, if you have questions or you have thoughts that you would like us to address, by all means, you feel free to drop something in the comment column, and we'll address them, comment or question otherwise. And I think the place to begin, and Peter, and let me introduce Kevin Owen. Kevin is a very talented lawyer who's has handled many cases now before the MSPB, whistleblower cases as well as other forms, arbitrations and so forth. But Peter, Kevin, ran the rest of the panel. I would say the place to begin is to note that in the United States, one thing that sets us a bit apart from the rest of the world is the fact that government employees, under most instances, actually have constitutional protection of their jobs. And that alone goes a great distance to ensuring that there'd be integrity in the federal government. Peter, you want to comment on that to get us started here?
Yeah, Gary, thank you. So I'll preface my response, and I'll probably forget your question, by mentioning that I started out from law school with a reasonably large law firm doing labor work and litigation on the management side. And when my wife and I decided we would move to Washington, I had applied for a job with the Department of Justice. They took a very long time to clear me. One of my references that I used was a former Assistant Attorney General, who then happened to be the General Counsel of the American Federation of Government Employees, Lou Pelerzi. And he invited me to join AFG's staff there as one of their lawyers. And he could clear me immediately, a week. So I took the job. And that's when I started to develop, when I started working for AFG, a appreciation for federal service protections. And there are a lot of protections. And yes, the Constitution is one of them, but there's so many statutes and procedures, EEO, MSPB, grievance arbitration, many forums. The federal employees have an awful lot of rights compared to their private sector counterparts. Now, their private sector counterparts, if they are represented by labor unions, can negotiate their protections, and they do, along with their wages and conditions of employment. In the federal sector, collective bargaining is not nearly as effective. It's fringe bargaining. You don't bargain wages normally. You don't bargain retirement plans normally. You don't bargain anything that infringes seriously upon statutory management rights. So with all these protections and with all these forums, and although there are an awful lot of complaints filed by federal employees in these various forms, and remember that federal employees, by and large, get to litigate against their employer on company time. Think that happens at Amazon? I don't think so. But with all these protections, it all falls back frequently to the constitutional due process protections that sets a minimum standard of due process for actions that are basically serious adverse actions against federal employees. And who are the protectors here? Well, the protectors are, of course, the advocates. And in those, I include agency advocates who have a reasonable regard for the law, I believe, having been a management advocate myself, and the employee advocates. And of course, the institutions that administer these statutes. And more, because the Merit Systems Protection Board has been out of business for 5 years and is just starting now to produce some decisions, maybe 60 or 70 in the last month or so, since March 4th. That's been about a month. More and more, the unlikely protector of the federal employee is what? It's the United States Court of Appeals for the Federal Circuit, which has come down with constitutional due process protections, particularly with respect to penalty assessment and mitigation and due process in the adverse action reply process. So yes, Gary, I agree with you that everything we do, EEO, MSPB, FLRA, grievance arbitration, it all comes back to constitutional protections under the Fifth Amendment, property rights of federal employees, where the Supreme Court has determined that the federal employee does enjoy a property right in the job, and therefore it's enables the employee to take advantage of these constitutional protections. I hope I have not been too abstruse in my response to your question. I hope I've responded to what you've asked.
I think that was a good, appropriate response, I should say, Peter. Kevin, you want to weigh in?
Yeah, I think one of the other things to tag in here, and I always get nervous when I'm following on the heels of Mr. Broida's speaking. So Peter, jump in when I'm wrong, is the institutions. And one of the things, if you want to just look at just some of the recent discussions out there in the courts about the importance of the Merit Systems Protection Board and government agencies as institutions, not just looking at federal employee rights, but making sure we have a well-run government, is read the Fifth Circuit Court of Appeals decision in Feds for Medical Freedom that came down about a week and a half ago, 2 weeks ago. It made the news predominantly about the Fifth Circuit ending that stay on the COVID vaccine mandate for federal employees. But there's an entire discussion in there about the importance of the Civil Service Reform Act and the importance of federal employees having the rights to appeal to the Merit Systems Protection Board, cites to decisions from the Federal Circuit and Elgin, for example, about what chaos is created when we do not have a well-functioning administrative system such as the Merit Systems Protection Board. Because prior to the Civil Service Reform Act, a lot of the litigation was going to be wound up in the US district courts. And the Merit Systems Protection Board, the Civil Service Reform Act really consolidated that to make it much more administratively efficient. And I know there's a lot of my colleagues that may be listening today who roll their eyes if we refer to the MSPB as administratively efficient. And that's not necessarily a belief that I think would be something that I wouldn't be sympathetic towards, because I know a lot of my plaintiff side colleagues have had years of delays because of this Lucia issue, had years of delays on very important decisions impacting their clients' lives because there was a lack of quorum. And the actions of prior administrations leaving the board vacant has impacted thousands of people. And for my agency colleague friends, the crush of decisions that are coming in now that we have a board, now that the Lucia stays are no longer happening, is really going to be impacting agency operations because they're going to be litigating all these cases. And so having a well-functioning administrative operation at the MSPB so that employees' rights are litigated and so that agencies have closure on disputes in a timely fashion is going to benefit the government as a whole.
Ren? You're on mute.
Yeah, got it. As Peter said, you know, and Kevin, federal employees have privacy rights in the job. They have First Amendment rights. They can speak about matters of public interest. You know, and we all hearken back and remember the case where Harry Connick's father clamped down on the attorneys working under him. And of course, federal employees have due process rights. And that's the right to advance notice and an opportunity to reply. The critical thing is, and Kevin mentioned Title V, 752. Once you have a property right in your job, that's your due process rights are really distinct from your 752 rights. They're not the same thing. And agencies may often say, hey, you got notice, you got an opportunity to respond, but you know, so we're home free on due process, and that's right. Then you go over to 752, that's a little different, and you may not have gotten all your 752 rights, but that's harmless error, probably. That's not due process. And you know, for years, the board and the Federal Circuit to some extent just focused on 752 and harmless error. And so when you look at this ball of wax, keep that distinction in mind. And when you look at these old cases, especially from the board, bear in mind that a lot of those would not be decided the same way when we've cleaned off the window pane and we see the distinction that we apply now clearly between due process 752 and harmless error. Those are my thoughts, Gary.
Okay. Anybody else care to weigh in here? Ed? I'll take that as a no. So there are a number of other protections, of course, besides the constitutional protections that are afforded federal employees. The one that was most near and dear to Ernie, of course, were the protections of EEO protections. Those that are provided either by the EEOC or in the case of mixed cases, the MSPB. And one of the things I think is most important about the work that the EEOC does, not only is it, of course, enforcing the Title VII and the other discrimination statutes, but it is what causes us to have a civil service that is a reflection of society as a whole. I grew up in Washington, D.C., and one thing I will tell you is when I was a young boy growing up, one thing that you never saw in Washington, D.C. was a Black police officer. And did it matter? Yeah, it does make a matter. It makes a huge difference to not have government services provided by, again, an entity that reflects upon who we are. And the world has certainly come a long way since passage of Title VII of the Civil Rights Act and some other statutes. But I think the importance of the Commission's federal sector work can't be understated. And let me throw that out there and see, Dwight, maybe why don't I turn to you first, see if you want to comment.
Comment about what specifically?
The importance of Title VII as it relates to the EEOC's work in Title VII, and how it ensures that we have a civil service that is in fact reflective of who we are. As a former chief judge in Dallas, how important is it? When you get right down to it, how important is it? Is it a statute that doesn't matter, and it's a
It absolutely matters, and over the years, with a number of cases that I've seen where people, there's a uniqueness about the federal sector that benefits employees, and I think in ways, I know that it takes a long time. I know that the commission as a whole is underfunded, and so that there's some inefficiencies in the process that the process deserves some criticism for that. I don't know that that'll ever be corrected, but at least provides a forum for people who have faced discrimination. And the thing about discrimination is, I had a person once tell me it was a manager who had always loathed discrimination complaints because they were always lodged against him, and he thought it was not only an inefficient process but completely unnecessary. And in the later stages of his life, he was discriminated against himself, and finally realized the value of it, and called me to tell me how much he had suffered, that it was beyond his imagination before this happened to him, how much he lost in not only monetary things, but self-esteem and the loss of his position and that sort of thing, and really sort of at that point understood the value of EEO law for the first time after spending so much time criticizing it. And I remember, and you may remember this, Gary, I don't know if you do or not, but there was an assault against the federal sector system. I think it was Castillo, who was the chair at the time. And she wanted to remove hearings and decided that it should look more like the private sector process, which is itself has its own problems. And they asked me to speak, I guess, so that my head could be chopped off rather than somebody else's when this is all done. But and I told her that instead of making the federal sector process look like the private sector process should look more like the federal sector process. And she didn't appreciate that comment at all and sort of told me that later. But I just had to speak the truth. And the truth is that you now have a system which fairly investigates for the agency to know exactly what happened if it's done well. In some cases, you have investigations that aren't done as well as others. But for the most part, you get to the heart of the matter, and you have enough information to know what took place, and you're in a position to resolve it. But if you're not, then you can move forward to further litigation steps. And I think it's more complex than it was before. You and I both operated under 1613, which is a much more informal process. And in some ways, I liked it better because it was informal, it allowed more people to participate without all the complexities that we have now. But still, it's a process that really allows people who have suffered greatly a chance to have some light shine on what actually happened to them, so that there can be some resolution of the problem. And I think that's invaluable. That's just invaluable.
Yeah, I have to agree. I don't have to agree with you. I do agree with you, Dwight. And I do think for all the faults that the criticisms that we may have about the federal sector, for the delays, the length of time it takes to get to a final adjudication, as well as appeals, the fact that it's overburdened with too many cases, including, as Ernie wrote some years ago, too many that don't have merit. The reality is, it's a good process. It's a real good process. It has a degree of informality with some degree of formality. It enables people at far less expense to prosecute cases where they think there's been an injustice. It provides an opportunity for a forum, and I do think that the commission has, unfortunately, used a Band-Aid approach to the difficulties, and so we have procedures such as the current MD that really have more Band-Aids than they do original substance to the procedure. But it is a process that gives everybody their opportunity to be heard, and that is so very important. And I will also say that one thing I think people often talk about the relatively small number of decisions from the EOC that have a finding of discrimination. Well, there's a real simple answer to that. You see the same thing in the federal courts, by the way, which is what happens to most of the cases that have merit?
They get settled.
They settle. That's
Yeah.
right.
Yeah.
They settle. And those that don't settle, oftentimes when there's a decision from a judge, they don't go up on appeal. The agencies either accept them or they settle them, and therefore there's no published decision. So I think we sometimes don't realize that. And for those, we have a lot of folks who are attending today who are on agency side. And I will tell you, I think I've always said defense counsel can do more good than plaintiff's counsel. And I always say that. Why? Because plaintiff's counsel can take a broken life and try to put it back together again. But a good defense counsel can stop bad things from happening. And I think it's really important for those of us. We do a lot of, we do not a lot, we do a fair amount of defense work as well as plaintiff side work. And one thing to bear in mind is just like in the criminal system, the price we pay to ensure that people are not incarcerated wrongfully is sometimes the system lets people go that should have been convicted. And it's somewhat the same way on the federal sector process, which is sometimes cases clog up the system that don't have merit. And I sometimes hear agency counsel complain that it's that those cases are distraction and they eat taxpayers' money and so forth. Well, the fact of the matter is that is the price we pay. We want anyone who has a substantive matter, who believes that they were the victim of discrimination because of the color of their skin or their disability or pregnancy or whatever the reason may be, we want them to file a complaint. And if the price we pay for that is that we have to deal with a fair number of cases that don't have merit, so be it. And the last comment I'll make about that is we would have so far fewer cases if managers did a better job of explaining the reasons they made decisions. Because the most common reason we have non-meritorious, I'm not going to call them frivolous because there are very few frivolous cases. The main reason we have non-meritorious cases that are filed in the federal sector is because people have something bad happen to them in the workplace. There's no explanation for why it was done. And we all think I think I'm the best qualified person for every job I've applied for. I think I write better than anybody. We all think well of ourselves. And if nobody explains why they made the decision and we eliminate all the meritorious reasons, then we're left with the question of scratching our head and saying, can it be the color of my skin or my gender or my disability or whatever? Kevin, you look like you were going to weigh in.
That advice goes true also on the adverse action cases that we handle. And going back to Ernie, there was a case that he and I handled a long time ago in which we were representing employees, and there were charges where their client was charged with failing to follow instructions, except there was no documentation as to what the instruction was. Agency lost that case. There's just a number of cases in which management and supervisors documenting and taking actions would benefit their agency far better than not tracking what they're doing. Employment performance cases are a great example, and that is an area that is I think overly politicized over the last 40 years. Congress loves to talk about how hard it is to fire a federal employee for poor performance. It's not that hard. It just requires supervisors to be able to track performance. And a lot of my employee relations colleagues and friends, when the last administration was pushing a rule that PIPs would only last for 30 days, calendar-wise, it doesn't benefit agencies to have a 30-day long PIP. It benefits the employees because anyone, you have 30 days, you got weekends in there, you have federal holidays, you may have a sick day. You're looking at 16, 18 days of actual work that these 30-day PIPs would be. Anyone can put in their performance standards and meet expectations in 16 days. And what is the supervisor going to be able to document in order to remove an employee? It's the ability to afford employees their opportunities to be able to improve, afford employees the opportunity to show their commitment to federal service that benefits the federal service, and not just being able to turn federal employees into de facto at-will employees that we see in a lot of these policies that are being pushed.
Yeah, and I've always thought, I was listening to case after case, and I think that if there are problems on the complainant side too. No, there's no question about that. But on the agency side, if they took a broader view of these cases, they could actually look to something that would benefit them in the long run. Because if you take the sort of limited, narrow view of some of these cases and say that despite the fact that the agency may have done this wrong or that wrong, that it's not a case of discrimination, therefore they're going to take the case to hearing, which is what I saw in some cases. No, it may not have been a case of a form of discrimination, but there was a problem that needed some managerial correction. And I in my entire career, I noticed that there was one agency, and I don't know how long they did it, but they would do sort of an after action report after a case was over, whether they won or lost, and they would determine what mistakes they made. There sometimes that there were contract provisions that were not interpreted properly, that needed correction. There are problems that you can correct in a system if you can discover them, because they come out in these cases often, and administrative judges may come to the conclusion that it's not a formal case of discrimination because they don't meet the criteria for employment discrimination, but still something went wrong. Whether it's as simple as a communication error and communicating to your employees or something like that. There's always something that you can find in these cases that can be used as a tool to correct some potential managerial defect in how they do their business. And so, but people sort of walk away and say, no, well, it wasn't a case of discrimination, and just blow it off and go on to the next case, missing the opportunity to fix something that might have been broken otherwise. Gary, you're muted.
That's much better. Why don't we take another 5-minute break, and then we'll see if we can wrap up in about 45 minutes from now. So let's take a break and come back. Why don't we come back at 2:10? So before we get on with the discussion of employee rights, there's a couple of comments I just want to pick up that we didn't get before. One of them, let's see. So one of the comments, Stephanie Herrera, who I know quite well, she worked with her for many years practicing law. Stephanie has gone on and has been with the EEOC as administrative judge and acting chief administrative judge, and is doing really good things there. But I just wanted to share a comment from Stephanie, which is the following. Ernie treated all of us new attorneys as equals. And she's not a new attorney, but she's referring to some time back when she was a new attorney. He was so persuasive using the least amount of words. He so easily came up with the hook for a case that would draw you in and would become theme of the case for a hearing. He rattled off case names just off the top of his head. He was an amazing mentor and leader. And that's actually for, I sort of forgotten about Ernie's focus on having a theme of the litigation, something that he was really big on and very much agreed. Also, Natanya Davis, who if she was on, I didn't see before, is with us. And do we have Natanya able to speak?
Yes, I've just promoted her to panelist. I think will be able to unmute in a moment.
I'd like a promotion if you're giving out promotions. Hey, Natanya, welcome.
Hi, all. I'm very sorry for my delay. Thank you for having me.
Of course. So, Natanya, you knew Ernie pretty well because there came a point in time where you did some of the heavy lifting for him, so to speak. Yeah, Ernie got a lot of the credit for and deserved. I mean, he did a wonderful job developing the book, but there came a point in time where you deserve a lot of the credit. So you want to go ahead and share your thoughts about Ernie?
Yeah, thanks. Over the course of years, I remember when I started, for those of you who don't know me, I worked for Peter as his one and only associate in his entire career, which as a young associate, I felt like, okay, great, I got a job. But as I've gotten older, I really appreciate the opportunity it gave me and fully understand what a wonderful compliment it was, because as time came and time went, there were no subsequent associates and there were no preceding ones. But I do remember being a very green, very new attorney, and Felchie would have their annual conferences in DC. And I do have such fond memories of those were the times that my first interactions with Ernie. And he would always stop by my office and chat me up and didn't make me feel like the green attorney that I was. I would echo what someone else was talking about, which is that he was just so fundamentally fair in all of his interactions and so incredibly kind. And I think that that was also echoed in the work that he did, just this notion of fundamental fairness and making things, ensuring that the civil service is in fact civil, right? And so I have wonderful memories of Ernie from the beginning. And as time wore on, he wanted to move on to fiction writing, which now that I have my arms fully wrapped around the EEO guide, me too. I would love to switch to fiction writing as well. Although I'm struck year after year, case after case, as I read these cases, I'm struck that some of these cases do read like a fiction novel. You would wish that these things didn't actually happen, that they're not still actually happening, but they are. And as I began working for Ernie in that capacity and started reading the 300 to 500 cases per month that the EEOC churns out, God bless their hearts, every month. And he was always very generous of his time, though he was paying me, right? He was so generous with his time and his wisdom that he had acquired over the years. I was never nervous about making a phone call, about having that time with him, that I was going to waste his time, or that he was above it, or had better things to do. That was never left with that impression, which was so nice. And then I, of course, went on to, when he finally was like, and we're done, I went on. I have the great privilege of taking over a treatise that really is just so well developed, so well thought out. And not only did I get the opportunity to learn about who Ernie is with my interactions, but that sort of spirit lives on in the book, because I have not read the book cover to cover, I will admit to everyone. That would take me eons. But every time I encounter a new section that I've not been through before, because there's a case that informs that section, and I want to add to it, I have the great privilege of hearing Ernie's words again, and being able to read his thoughts and his wisdom as it relates to these new sections that I've not read before. So I feel like I continue to get to know Ernie as time has worn on, and I have interacted with every section of the book at this point. So he was just a wonderful man, and it's been a great loss, I think, for many, many of us who have known him over the years. And I really appreciate your considering me and inviting me to be a part of this.
Well, thanks very much for being here today. And if there's other folks who you could feel free to use the chat box if you have remembrances of Ernie or comments that you'd like to share. I think they are also interesting. Why don't we talk for a moment about another protection? I think that the fact that we have a federal workforce, which at least in theory should be empowered to speak up when they see injustices, improprieties, waste in the government. Again, something that makes a dramatic difference in terms of ensuring that the government is, in fact, free from inappropriate pressures or graft and political coercion. And of course, prime among those are the whistleblower laws, the revised whistleblower law, the WEPA. And let's talk about the significance of that in our. Who would like to get us started on that conversation? Well, I'm not mistaken, Kevin. It looks like you just got elected.
I can.
I was going to
Oh,
nominate Mr. Broida.
Go ahead, Peter.
I was just
jumping in there.
learning how to operate the computer.
Yeah.
There I am.
Yeah.
Well, I want to say, first of all, hi, Natanya. It's been a while since I've seen you. You'll notice my hair is grayer, but it's still there. You know?
It is, but you have it, and that is significant. Reagan can tell you.
Well, my kind regards to your wonderful husband. Gary, you've asked about the whistleblower law. So here's what's happened with the whistleblower law. The Merit Systems Protection Board, by design in 1978, could adjudicate a small class, but an important class of cases, basically adverse actions and performance-based actions, of which there have been very, very few. So it's basically adverse actions. Now, there are other things that the board looks at, but that was their workload. You can add into that, of course, retirement appeals from the Office of Personnel Management. And I'm not forgetting VO and USERA and all that, but that was their primary work. Then along comes the statutes, the whistleblower protection statutes that create the individual right of action. And this was a revolution for civil service law and a complete change for the Merit Systems Protection Board, because what it did was to require, not allow, but require the board to adjudicate all manner of personnel actions or inactions that they previously had not had jurisdiction over. And the closest analog is, yes, that's right, EEO. Any type of discriminatory act, any type of personnel action, any type of lack of personnel action. So the jurisdiction of the board increased hugely with the whistleblower cases, and people started filing a lot of these cases, just like they file a great number of EEO cases. And yes, some of them are unfounded. The difficulty with the law is that the law is so broadly stated with respect to what does or does not constitute reprisal. How does or how does not the burden of proof get established or rebutted, that it's taken 10 or 15 years to try to sort this out through hundreds of cases to the Merit Systems Protection Board, then to the Federal Circuit. Both the Merit Systems Protection Board and the Federal Circuit were criticized in Congress for being ineffective, and I may add into that the Office of Special Counsel. Laws were passed to try to enhance the Office of Special Counsel, to reverse some of the law that had been created by the Merit Systems Protection Board and the Federal Circuit. And even as recently as 3 or 4 days ago in the Rickett decision in the Federal Circuit, a whistleblower case, of course, the law is still being developed. Add to the mix, just as occurred with EEO, the ability to obtain under the Whistleblower Protection Enhancement Amendments and the Whistleblower Protection Act compensatory and previously consequential damages. And you have an incentive for people who believe they are whistleblowers to take their cases into the board, go out and get counsel who might, if they win, get counsel fees. And it's really increased the volume of litigation at the board. There are not many cases that are decided in favor of whistleblowers, just like in the EEO arena. When you get right down to it, at the decisional level, if you look at the input vastly exceeds the output of decisions that favor complainants, either at the EEOC or the Merit Systems Protection Board. So Congress wants people to be whistleblowers. Congress wants people to report to Congress the improprieties, the inefficiencies that occur within the federal civil service. Not all whistleblowers are going to Congress, but Congress encourages the reports They take a considerable interest in it. And the best I can say about this, Gary, just like EEO, it is that the law continues to develop. And I think with the current membership of the board, particularly when they get a chair who is a Democratic appointee, I think you'll find that whistleblower protections are further refined. The relief that the whistleblowers who are successful receive, you'll get a better body of precedent for people like you and Mr. Fowler to write about. And I'm looking forward to being around when all that occurs, but it's been a very long project in its evolution, Gary.
You know, to a great degree, the one area of employment law where that has been somewhat bipartisan and has certainly been consistently protected through the federal courts is protections against retaliation. We've certainly seen that in Title VII, where the Supreme Court has been unanimous on any number of cases applying the law in cases of retaliation. And even when they haven't been unanimous, they have been very close to that on retaliation. And we've seen both from the both sides of the aisle, so to speak. Generally, we have seen support for the concept of wanting federal employees to be in a position to report those kinds of gross misconduct or waste and fraud whenever possible. So yeah, I certainly agree with the comments you're making, Peter. But I do think we should note that it's had a fair amount of support from both sides of the aisle. Ren, Kevin, anybody want to?
Well, Gary, this is Ren. May I say this, and you know, nobody can speak better and more completely than Peter. But I would just add, you know, through the years, you know, we had the Whistleblower Protection Act, as Peter said. Then we've had other amendments and the Enhancement Act, and those acts have really made it easy for disclosures, as Peter was saying, to qualify and be protected. So that's a big improvement. I would say, Gary, you and I had a case about a year ago where the Federal Circuit, in effect, struck down some board regulations saying, and it was Kammungun, Kammunkun, that managers did not have to make an election whether to grieve, go to OSC or to the board. And that was important because you know, your IRAs, your scope of what's considered is limited to solely whistleblowing. So that Kammungun case was a big case too. I think OSC is a very good agency. It really is. But they're, quite frankly, Congress gives them, figuratively speaking, a teaspoon and says, go empty the tidal basin. They can't do it. And you know, so the IRA became quite important. You know, Peter mentioned damages, and unlike EEOC, those damages are not capped under the OSC statutes or the whistleblower statutes more properly. So, you know, I just sit back and think where we are. I mean, it's pretty easy to make a case for protected disclosure. Causation gets a little more difficult. I mean, you have some easy tests, knowledge, timing, and so forth. But then the burden, if someone makes their prima facie case, the burden switches to the agency to prove by clear and convincing evidence that they would have taken the same action absent the protected disclosure. And clear and convincing is a civil fraud burden, and it's just a teeny bit below beyond a reasonable doubt. I think if there's one bit of advice I would have on this subject for the agencies, it seems to me the agencies often take too lightly the problems that agencies can face, proving that they would have taken the action in any event. And slightly in that connection, if I may say this, and sort of hearken back to what you, Gary, and Dwight were saying, I see so many cases where, well, it's not discrimination or it's not reprisal for whistleblowing, but yet there was a wrong. And as Dwight said, there was a serious problem. And you know, when you go in the Justice Department, in the rotunda, there's carved there in those in the stone, the government wins whenever the right thing is done. And so a lot of times we approach agency counsel and really not in such an adversary sense, but let's get the paste back in the tube. Let's get the wheels back on. And I would really like to see more of a collaborative effort there, you know, not just in whistleblowing, but you, Dwight, and this whistleblowing provoked that thought. That's what I had, Gary.
Interesting comments, Rand. Anyone else want to comment on?
And I think just over the last 15 years, we've seen a remarkable increase, not just in how the board has been looking at whistleblowing protection in the federal circuit's case law, but really just the reconstitution and muscle that OSC has developed since 2008. There's been a significant increase in the number of staff that OSC has hired. They have really taken on new initiatives. And you know, I represent employees at OSC. I represent employees who are the targets of OSC investigations, and I've advised agencies when OSC comes knocking about whistleblower complaints. And agencies and employees really ought to make use of OSC's resources when they're dealing with these sorts of disputes that touch on whistleblower or other PPPs that OSC has taken on. And one agency that I think has really learned that lesson is the VA, in light of 38 USC 714, which is the VA Accountability and Whistleblower Protection Act, which only applies really to the VA. It did lower some burdens of proof on agencies and able to remove employees with adverse actions. But the one important thing that did is it created an automatic stay for anyone who has a case pending for OSC. And that has been a lifesaver for a lot of clients. And it has really allowed OSC to look through a lot of patient safety issues that would not have otherwise come to light had there not been this bigger procedural safeguard for the federal employees over at the VA. So whether or not Congress extends that to all federal employees, I don't know. I know there has been some push and analysis for that. But utilizing OSC for both a mediation and paying attention when they're investigating what's going on in your agency is going to be crucial. And I don't see anything lightening up from the way OSC has been moving since Carolyn Lerner was special counsel.
I think Ed wanted to weigh in, and if Ed doesn't address this point, let's pick up the conversation at some point by talking about the importance of the ability of the special counsel to seek a stay. But Ed, go ahead.
Yes, I had agree, of course, that over the years, federal employees have a lot more rights than they ever have previously. But one thing that hasn't changed that I've noticed is that federal agencies are still reluctant to resolve cases early on. I mean, in the informal EO process or when you get a proposed adverse action. For some reason, they just stick their heads in the sand, even though down the road, the case will ultimately settle. But in the early stages, they don't want to address the issues. And as Ren pointed out, they're often, it may not be discrimination, but there's something that's wrong there in the workplace and they don't want to deal with it. And that is very troubling because even now in the current administration, I don't see any change in agency attitudes. I've gone into some recent EEO settlements where I know the case has some merit, and at the very minimum, the employees are mistreated. But the other side just blows me off. And I just find that to be very discouraging.
Peter, you want to weigh in on, if nothing else, on the importance of OSC being able to seek stays?
Yes, I do so, knowing that OSC has not been able to obtain a stay in 5 or 6 years, and I don't know what their current approach is. I do know that they have whistleblower cases where they're not seeking stays, but is it important? Sure, it's important, but, and here's a very big but, you got to go to them at the right point. The law is very convoluted as a result, principally of the Merit Systems Protection Board, that if you're going to seek a stay, you want to do it at the proposal stage and not at the decision stage. Because if you do it at the decision stage, what you end up with is if the special counsel doesn't take action, eventually an appeal to the Merit Systems Protection Board as an individual right of action, where you have managed to lose your affirmative defenses and due process defenses and mitigation defenses. And I think what needs to be changed is that distinction. It's too confusing for people. The agencies don't parse it right sometimes in their decision letters or their proposal letters. So I think the ability to get a stay is important. The Office of Special Counsel traditionally has not often sought stays. You're correct, Kevin, that the statute that's particularly designed to the Veterans Administration relies upon a provision that grants an automatic stay if you allege whistleblower retaliation to either the special counsel or to the VA organization that's supposed to oversee this, which results in everybody alleging whistleblower reprisal, of course. But to answer your question, Gary, it's an important power, but it's one that has to be chosen very carefully by either an informed employee or an informed advocate to avoid some type of later harm in the appellate process.
I'm on mute. Ren, Kevin, anybody? Ed, you?
Gary.
Yes, Ren.
Yeah. May I just say, Peter was so right. Those regs that the case Communion that you and I had, and we finally worked our way through it, and we won. Those regs that the board has, to some extent, they are wrong, but they are so counterintuitive. You really have to be careful, and you know, when Peter mentioned that, I hope everyone was taking notes.
Anybody else care to weigh on that? How about we just have a very brief chat about procedural issue, which is somewhat unique, and that is final agency decisions. Allows an employee to not spend any. You don't even need a lawyer, right? You can file a complaint in the EEO process, get a report of investigation, ask for a decision, albeit from the agency, with a right to appeal that to the EEOC. Good thing, bad thing. Dwight, you want to start us there? Dwight, you're on mute. I could tell you were probably really eloquent, but
not really. No, I've always had questions about final agency decisions and how they're actually done. I've also had some questions about appeals and how they're actually accomplished, whether or not the agency actually has a chance to add additional information after the record is complete at the hearing stage, when the case goes forward before both parties get to weigh in. And you know, I think it's certainly an excellent vehicle if based upon the investigation, the case shows that there was likely discrimination in the case, because under those circumstances, either party should have a chance to further develop the record, to add additional affidavits or other evidence, as an example. I did talk to, but I was always a little bit skeptical about how the case would come out based upon an final agency decision without, you know, some third party actually assisting the complainant and providing, you know, additional information for the record. But I talked to several EEO officers who claimed that it was absolutely an independent review, that there was just as much of a likelihood as the finding of discrimination based upon a final agency decision as with the administrative judge. I was always skeptical about that, so I'm not really quite sure about that process, except under circumstances where you have a strong record going in, because typically that means that if you don't have a strong enough record, it typically means that you have to you know, supplement the record, and that's basically what the hearings process was established to do, is provide additional information that might have been missed during the investigative stage. So while I think it is especially a great tool for people who don't want to go through the complexities of litigation, the expense of litigation, the time it takes to go through litigation through the hearings process, I realize that there's some advantages in requesting a final agency decision under those circumstances. And maybe I'm biased because I've always been in the hearings part of the process and never been involved in the with final agency decisions. But I just don't think, you know, for my money, I would go with a hearing as opposed to a final agency decision. But I understand that there are contrary positions out there on that.
Anybody else want to weigh in on that? So let's talk about protections that employees have through the benefit of negotiated agreements. Of course, the federal sector labor side is for the most part overseen by the authority, the Federal Labor Relations Authority. We have some experts here. Ed, you had some experience in the early years of your career in labor law, and Peter, you've written what I think most people would consider the Bible for matters before the authority. Ren's got some significant experience. We got a real panel here. What do you think? What are the importance of unions in the government today? Is it, and take a look in your crystal ball and tell us what the future holds for negotiated agreements and union activity in the federal government.
Gary, I'm going to talk to just one portion of your question. I can't predict the direction things will go. Certainly, President Biden wants more involvement of unions in, shall we call it, the oversight of the federal workplace. The Office of Personnel Management has sent out at least 3 letters to agency heads encouraging union involvement at various steps. the Federal Labor Relations Authority continues to be restrictive because of their membership of aspects of labor relations that will probably change with the change in membership, which is not unexpected. The principal benefit that I see for a labor contract is the ability to use the grievance process and grievance arbitration, particularly, especially, maybe only for adverse actions or serious disciplinary actions. Why? Because I think if an arbitrator is chosen who's experienced, it's far more likely that the grievant, the union, will obtain some relief for the employee, and assuming the employee is not a complete screw-up, that would not be available through the Merit Systems Protection Board, which still has a function of upholding agency penalty decisions as long as they're arguably reasonable if the facts support the charges. And often the facts support the charges, but the penalties, in my estimation, are overkill. So the difficulty is that unlike the private sector, remember I came out of the private sector, the union membership is voluntary. Everybody's included in the unit, but because of voluntary union membership, the due structure is historically low. The unions don't have the money that they do in the private sector to take lots of cases to arbitration. And then we get back to a procedural problem that Ren and I were talking about, the elections of remedies, where you can have a situation with an adverse action that an employee who listens to comments like mine says, wow, I'm going to get myself here arbitration rather than the MSPB to look at this adverse action, files a grievance, and that grievance, just the filing of the grievance, elects the remedy between grievance arbitration and the MSPB, and the union is not obligated to take every grievance to arbitration. They're selective. They do have a duty of fair representation, to be sure, but that's a very high bar for someone to meet to show that the union didn't meet their duty of fair representation. So that election of remedies, if it's unwisely made by the employee who thinks but will not get arbitration, means that the employee ends up with no process at all, no hearing, no arbitration, no MSPB. So if I had my way, I would find a way to avoid that election of remedies by modifying the statute, but nobody elected me to Congress. But all things aside like that, those procedural problems, that's a terrific benefit to be able to get to a labor arbitrator who's truly neutral, who makes their living out of cases that are brought to the arbitrator by the unions and management, and has an interest professionally, economically, it's a little business, of not only being perceived as being fair, but also being fair. And with all the regard that I have for the Merit Systems Protection Board, you got to keep in mind what their charter is, and that's to uphold penalties as long as the facts support them and the penalties are not completely unreasonable. Gary.
I think we might see more well-written decisions from both the EEOC and MSPB judges if they had to rely upon parties mutually coming to retain them to do their work, instead of seeing decisions that sometimes the losing side scratches their head and says, if only the judge had explained to us what the heck the judge was thinking. So yeah, that's a very good comment, Peter. We're going to wrap up in the next couple of minutes. Yeah, absolutely.
Yeah, no, I agree with Peter's comments. If you have a case where the employee did something wrong but doesn't deserve, say, removal, you're much better off before a labor arbitrator who will mitigate, unlike the board administrative judges who are afraid to mitigate penalties. But the other point that Peter made is absolutely correct. It's so complicated that you really should have a lawyer when you file the grievance so you get your affirmative defenses in, otherwise you're going to lose them. But more importantly, what I've urged employees who are represented by unions, you need to get in writing the union's commitment to arbitrate the case before you file a grievance. If you don't get that in writing, forget it. You're going to end up, the union will decide not to take the case to arbitration, and you'll lose all your remedies.
Well, let me say spirited conversation, and I certainly thought it was interesting. I know Ernie would have had a lot to say today were he here. And I know that Ernie would be touched that a discussion of protections for federal employees was a topic of discussion and a tribute to him. Let me invite our the folks on the panel, anyone, if there's any final comments you want to make. Otherwise, we will let these good folks get back to the other things they may have to accomplish. Any final comments? I'll just say, God, I miss Ernie. I miss him so much. Thanks so much for attending, and everybody stay safe, be well.